Throughout our country's history, many have risen up in protest of unfair, unequal, and oppressive practices. Through diplomatic action, the constitutionality of such injustices has been decided by the ultimate judicial authority, the Supreme Court. It is here that the inalienable rights of human beings have been affirmed. Here that the ideals of freedom and justice have been pitted against convention. And it is here that the legality of interracial marriage was decided for the last time in the United States in the landmark case, Loving v. Virginia.
In June 1958, amidst the social upheaval of the Civil Rights Movement, Mildred Jeter, a woman of Native American and African American descent, and Richard Loving, a white man, traveled to Washington, D.C. to get married. By traveling out of state, the couple was able to escape the bans on interracial marriage imposed in their native Virginia. Upon returning home, however, they faced hardships.
It was about 2 a.m. and I saw this light, and I woke up and it was the policeman standing beside the bed and he told us to get up, that we was under arrest.
The couple pleaded guilty to violating the Racial Integrity Act of 1924, which prohibited interracial marriage. Judge Leon Brazil sentenced the Lovings to 1 year in prison, but suspended the sentence for 25 years on the condition that the Lovings leave Virginia. Brazil stated his opinion that
Almighty God created the right races, white, black, yellow, Malay, and red, and he placed them on separate continents.
Uprooted from her home and torn from her extended family, Mildred Loving petitioned Attorney General Robert F. Kennedy requesting help. The American Civil Liberties Union then adopted her case and appealed it to the Virginia Supreme Court of Appeals. Their efforts were futile, however, since the Court of Appeals upheld the first ruling. As a last measure, the Lovings looked to the Supreme Court for help. In 1967, the court unanimously ruled to invalidate all laws limiting interracial marriage, overturning the policies of 16 states and freeing many Americans from legal oppression. This decision invalidated the notion that equal punishment of both parties, regardless of race, constituted justice.
And the United States Supreme Court says, now, any rights you have or don't have that turn on whether you're a particular race or not a particular race is inherently unconstitutional.
The existence of such race-based classifications violated the 14th Amendment. Though unequivocally a success for the cause of interracial marriage justice, this decision did little to sway public intolerance of the practice.
And even though the court issued that decision, that doesn't mean there is broad social acceptance of interracial marriage. There's articles that are contemporary with the court's opinion that talk about the extent to which interracial couples still experience, scorn and prejudice, and even continuing decades later, there's still public opinions are critical of interracial marriage. So there's a difference between kind of the legal acceptance of it and the social acceptance.
despite the court's ruling, prejudice prevailed. Those opposed to mixed-race marriage continued to deny the right to marry to interracial couples through non-compliance with the law, as well as public protests of the practice. A 1971 letter published in the Pennsylvania Beaver County Times, entitled "Hitler May Have Been Partly Right, Student Believes," preached purity of the races, stating, "We cannot allow our worst elements to control our destiny. The test for a government is whether it stands for the preservation and integrity of its productive elements. Governmental degradation of these elements by subsidizing the parasitic elements who create the problems of crime, illegitimacy, racial miscegenation, etc., only shows its degeneracy." This tirade against miscegenation was not unique in its criticism. Many newspapers detailed the struggles of interracial couples. In 1980, an article in Alabama's Gadsden Times revealed the non-compliance of the judge Felix Felton, who refused to issue a marriage license to interracial couple Edward Sharpley and Thalia Autumn, ruling, "They knocked it out of the code, but I don't know of anything they put in saying I had to marry them." The Southern Nationalist Party also opposed interracial unions and worked to solve them.
There was a big tension between what the court decisions were and what the rest of society, or at least large segments of the population, were willing to accept, embrace, and go along with. And it was just a long, long struggle.
Such social resentment was common. A 1968 poll showed that only 20% of Americans supported miscegenation, while 73% opposed it. It wasn't until 1997 that a majority of Americans supported interracial marriage.
For those willing to brave social criticism and judicial roadblocks, however, the Loving v. Virginia decision was a monumental achievement. Following this decision, the number of interracial couples began to increase rapidly. These numbers would continue to climb. By 1980, this figure rose to 2%, and in the next 12 years, it rose another 0.2%. Not only did the case allow couples to legally reside anywhere in the United States, it also proved to be a catalyst for legislative change. Just 10 months after the Supreme Court struck down anti-miscegenation laws, President Johnson signed the Civil Rights Act of 1968.
This act, also referred to as the Fair Housing Act, prohibited discrimination by sellers or renters of property. This allowed interracial couples, as well as any others facing discrimination, to find lodging, even among those opposed to their lifestyle. Later, in 1988, the Civil Rights Restoration Act passed, expanding the reach of non-discrimination laws within private institutions receiving federal funds. Laws like these somewhat eased the struggles of interracial couples who were subject to the social intolerance which, though slowly lessening, still remained. The limited social acceptance of miscegenation paralleled other aspects of the civil rights movement. The principles of interracial marriage reflected those of integration, an issue which had been decided in the Brown v. Board of Education case just 3 years before the Lovings.
Social interaction, just changing over time. That is, as we have gotten rid of social segregation, social spaces, school spaces become integrated, and essentially, you might say, families are becoming more integrated as well.
Despite these strides, however, cultural biases continue to dissuade interracial marriage.
Even after the Loving ruling, many states kept their original anti-miscegenation laws, which, despite being ineffectual, were a symbolic reminder that mixed-race marriage was neither supported nor accepted. A 1971 edition of the Waycross Journal-Herald, a Georgia newspaper, described this occurrence. Post-Civil War era laws against whites marrying blacks remain on the books across the South, even though the Supreme Court has ruled that such laws are unconstitutional. In fact, it wasn't until 2001 that Alabama repealed this anti-miscegenation law, and even then only 60% of citizens were in favor of this action.
In recent years, people have continued to commit hate crimes against interracial couples. In 2009, an African-American man, Jeffrey Wellmaker, was walking in a Phoenix park with his white girlfriend, Kelly Jager, when a man yelled, "What are you doing with that white woman?" After they left the park, the man shot at them, killing Jager. 2 years later, in San Francisco, Hosea Matavo attacked an interracial couple and their 2 young sons after he made a racist remark about the color of their children's skin. Perhaps it is events like these which discourage interracial couples from marrying. The 2010 census shows that a higher percentage of interethnic couples are unmarried than married.
Another possible hindrance is the opposition to the portrayal of interracial couples in the media. A May 2013 advertisement for Cheerios featuring an interracial couple and their biracial daughter generated a significant amount of racist backlash. Society places an unfair burden on interracial couples. They are discriminated against, scrutinized, and harassed. Though they have the same legal options as same-race couples, they often face a much more difficult set of obstacles. The Supreme Court decision in the case Loving v. Virginia did not substantially affect immediate social change, nor did it provide full equality. It did, however, free Americans from the legal burden imposed upon them by the unconstitutional laws which deprived them of their freedom and autonomy.
Hope is what led me here today. With a father from Kenya, a mother from Kansas, and a story that could only happen in the United States of America.